Meine sehr geehrten Damen und Herren, ich möchte mich als erstes für die leichte Verspätung entschuldigen. Wir hatten 2, 3 technische Hürden noch zu bewältigen. Nichtsdestotrotz begrüße ich Sie natürlich recht herzlich zu unserem heutigen Swissfort Talk zum Thema Innovationen schützen, Zugang sichern, Transparenz bei patentierten Pflanzeneigenschaften. Neue Züchtungstechnologien bieten eine große Chance für eine nachhaltigere Landwirtschaft. Mit diesen Innovationen rückt auch der Patentschutz in den Fokus. Die Politik auf EU-Ebene und in der Schweiz diskutiert aktuell, wie die Transparenz bei patentierten Pflanzeneigenschaften in der Praxis erhöht und der Zugang sichergestellt werden kann. Die zentrale Frage lautet, wie wird diese umgesetzt? Züchterinnen und Züchter sind auf den Zugang zu genetischem Material angewiesen. Gleichzeitig braucht es klare Regeln für den Schutz wie die Nutzung des geistigen Eigentums. In dem heutigen Talk möchten wir aufzeigen, wie diese Balance gelingt und welche Transparenzmodelle für Rechtssicherheit sorgen, ohne Innovationen zu bremsen. Dazu möchte ich jetzt unsere heutigen Redner herzlich begrüßen. Es sind dies Anaïc Cordoba vom Institut für geistiges Eigentum. Er wird in seiner Präsentation aufzeigen, wie Patente und Sortenschutz zusammenspielen und gibt einen Einblick in die aktuellen Entwicklungen rund um die Transparenz bei Patenten in der Pflanzenzüchtung. Danach wird uns Hélène Guillot von der Agricultural Crop Licensing Plattform erklären, wie Züchter einfach und rechtssicher auf geschütztes Material zugreifen können. Und Thorsten Berg von BASF wird uns dann noch einen Einblick auf die auf Gemüse ausgerichtete International Licensing Plattform geben. Die Referate von Anaïc Cordoba und Hélène Guillot werden auf Englisch gehalten. Das Referat von Thorsten Berg findet auf Deutsch statt. Ihre Fragen an die Referenten können im Anschluss auf Deutsch, Französisch oder Englisch gestellt werden. Sie können mir Ihre Fragen auch im Laufe der Präsentationen bereits in den Chat schicken. Ich stelle diese dann gerne ganz am Schluss in der Diskussionsrunde an die Referenten. Damit auch bereits genug von meiner Seite. I will now switch to English and I will hand over to Anaïc Cordoba from the Swiss Federal Institute of Intellectual Property. Anaïc, the stage is yours.
Thank you, Nico. Hello, everybody. So my name is Anaïc Cordoba, legal advisor at the IPI, and I will talk about innovation, plant breeding, and patent transparency. Plant breeding has always been about innovation. From crossing and selecting to today's gene editing technologies, breeders continuously develop new plants and new traits to address challenges such as climate change and food security. On the next slide, you can see a gene-edited banana developed by Tropic. This banana was named Time Magazine's Best Food Innovation of the Year 2025. What makes this banana special is very simple. After being cut, it does not turn brown. Behind this trait lies years of research, field trials, and investment. So how do we protect innovation like this? And what does this imply for breeders and plant breeding? The next slide shows the two intellectual property systems used to protect innovations in plant breeding. The first is plant variety protection. It protects the plant variety itself, for example, a new wheat or potato variety. It rewards the breeder for developing a new variety. The second system is patent protection. A patent protects a technical process for breeding or a specific trait obtained with such technical process. For example, this could be a genetic trait that gives plant better resistance to a disease. In Switzerland, under both systems, breeder can use existing plant for further breeding. This is essential because plant breeding builds on previous varieties. The main difference between the two systems appears when a new variety is commercialized. Under the plant variety protection system, the breeder can market the new variety freely as long as it is clearly distinct from the protected variety. Under patent law, if a new variety contains a patented trait, the breeder needs a license from the patent holder to market the new variety. So the key point is that these two systems are not competing. They protect different aspects of innovation and together they support plant breeding innovation. Today, I will mainly focus on patents because they are currently at the center of policy discussions. Next slide, please. While these two systems work together in practice, patents in plant breeding have been the subject of significant debate. Next slide, please. Next slide, please. Yes. No, not this one, the previous one. Yes. So, start it over. While these two systems work together in practice, patents in plant breeding have been the subject of significant debate. With the emergence of new genomic techniques, NGT, this debate has recently returned to the forefront. Three questions are often raised. First, can breeders use plants that contain a patented trait in their breeding programs? Second, can plants developed using NGT be patented? And third, how can breeders identify relevant patent in practice? To answer these questions, let's first take a closer look at what a patent actually is. That will be on the next slide. A patent is first and foremost a technical solution to a clearly defined technical problem. This means that abstract ideas, scientific discoveries, or natural laws cannot be patented. To obtain a patent, an invention must meet two key conditions. It must be new, meaning it has not been disclosed anywhere in the world, and it must involve an inventive step, meaning it must not be obvious to a skilled person in the field, so an engineer in the field. A patent grants an exclusive right. It allows the inventor to prevent others from using the invention. However, this right is limited. Patents last for a maximum of 20 years and are valid only in the country where they are granted. In return for the exclusive right, the invention must be fully disclosed, and patent applications are published in publicly accessible databases. Next slide, please. Obtaining a patent represents a real investment. Applicants must pay fees and go through an examination process with the help of a patent attorney. But patents are also a driver of innovation. Every patent application is published and adds new technical knowledge to the global pool of information. This information can be searched and used by researchers, engineers, and companies as a source of inspiration for further innovation. Finally, patents can facilitate collaboration and financing. They help structure partnerships, attract investment, and support new business initiatives. So now that we better understand what a patent is, let's see on the next slide what can be patented in plant breeding. The key principle is that plant varieties cannot be patented. The same applies to essentially biological breeding process. That means classical methods such as crossing plants and selecting the best offspring. Plants obtained from such processes are not patentable either. The same applies to naturally occurring genes. That's a discovery, and a discovery is not an invention and cannot be patented. Technical breeding process can be patented. These include techniques that directly modify genetic material, for example, genome editing methods, such as CRISPR, for example. Traits obtained through such technical processes may also be patented. For instance, a genetic trait that gives plants improved resistance to heat may be protected by a patent. What matters is that the invention is not limited to a single plant variety and that all the general conditions for patentability are fulfilled. Of course, in this presentation, I can only explain the general principle. In practice, each patent application must always be assessed on a case-by-case basis, and there is no simple yes or no answer. That said, the patent system also contains important safeguards for breeders, farmers, and researchers. We will see that on the next slide. For breeders, there is the breeders exemption. That means breeders can use plants with patented traits to develop new varieties freely. They don't need permission and they don't have to pay royalties. However, if the patented trait is still present in the new variety when it's commercialized, the breeder needs a license from the patent holder. The law also allows breeders to request such a license from the patent holder and, if necessary, enforce this right in court. For farmers, there is the farmer's privilege. Farmers who have lawfully purchased seeds may reuse year after year on their own farm the propagating material they harvest, even if it contains a patented trait. So they cannot be forced to buy new seeds because of patent right. Second, for farmers, it's the outcrossing exemption. If a field is naturally pollinated by wind or by animals with a plant carrying a patented trait, the farmer does not infringe the patent. He can freely sell the harvest. Finally, researchers benefit from a research exemption. They may study the invention, test it, or explore new applications freely. And if researchers need access to a patented biotechnology research tool, such as CRISPR, the law also provides the possibility of a compulsory license if reasonable access cannot be obtained on the market. So, you may now wonder whether NGT could make the current framework outdated. Let's take a look at that on the next slide. One point is often overlooked. The impact of patents mainly depends on how NGT are regulated. If NGT plants are regulated in a restrictive way, for example, similar to GMOs, their use in plant breeding will remain limited and patents will have little practical impact. If, on the other hand, NGT plants are regulated more like conventional varieties, the use will likely increase and we may see more patented traits used in plant breeding. The IPI has carried out a number of analyses and commissioned several studies. They show that Switzerland and its patent system provide an innovative and competitive environment for breeders and for breeding. Patent landscapes show that NGT patents are filed by both large companies and SMEs, and by public as well as private actors. Studies show that licensing is happening, including for CRISPR-Cas9 and other newer genome editing technologies. These elements explain why no modification of Swiss patent law is currently considered necessary with regard to NGT patents. So we see no short-term impact on breeding. And in the long term, however, if patented traits become widespread, access to genetic resource could become more complex. This is therefore something that needs to be monitored over time. And for farmers and consumers, our studies show no direct impact. The studies supporting this conclusion are available on our website. I will share the link in the chat after my presentation. Now let me briefly address transparency with the next slide. In practice, identifying relevant patent is not always easy. In the research and development process, patents usually appear several years before plant varieties. As a result, a patent does not indicate which variety will eventually contain the trait. At the same time, plant variety registers or official catalogs do not show whether a variety contains a patented trait. Improving transparency on this point would also improve legal certainty for breeders. On this basis, the IPI developed a draft proposal to create a transparency platform that would help breeders identify potentially relevant patents. The public consultation has already taken place, and while participants support the objective of improving transparency, stakeholders also emphasize that any Swiss solution should remain compatible with development in the European Union. This is especially relevant because discussions have also progressed at the EU level. The EU trilogue has recently reached a provisional agreement on the regulation of NGTs. Importantly, this agreement does not foresee a patent ban, but focus on transparency, licensing, and monitoring. The European text foresees the creation of a register for NGT1 plants, indicating related patents. It also proposed a code of conduct, encouraging stakeholders to improve transparency and to facilitate licensing. This approach builds on existing initiatives such as PINTO, ILP, and ACLP. In this context, the IPI is currently working with Swiss stakeholders to explore possible solutions. The Swiss situation presents specific challenges because transparency would need to cover all patents relevant for breeders, not only NGT patents. The objective is to develop a solution that works in practice for both breeders and patent holders, and that remains compatible with the emerging European solution. The proposal responding to the parliamentary motion is planned for submission to the Swiss Federal Council by the end of 2026. And I will conclude with a few key messages on the next slide. Patent and plant variety protection are often presented as conflicting systems. In reality, they protect different aspects of innovation, and together they form a system that supports plant breeding innovation. Second, plant as such and essentially biological breeding processes remain excluded from patent protection. The Swiss patent system already includes several safeguards for researchers, breeders, and farmers. Third, the impact of NGT patent on breeding will mainly depend on how NGT plants are regulated. And finally, transparency in plant breeding patents has become a key topic in current policy discussions. The challenge now is to turn this principle of transparency into a practical solution that supports innovation. Thank you.
Many thanks, Anaïc, for those insights. We continue in English, and it's my pleasure to hand over to Hélène Guillot from the ACLP for the next presentation. Welcome, Hélène.
Is muted?
You're still on mute, I think?
Yes, thank you.
Exactly, there you are.
Thank you for giving me the floor, and thank you for inviting the ACLP to present this initiative from the private sector. So after all the explanation that Anaïc gave, I think it's quite interesting for the audience to get an example of how the private sector came together, how some seed companies decided to facilitate the access to patented traits and to address some problems that are often raised with patents. So this initiative is quite new. It is officially registered since 3 years now. So I'm very happy to take this opportunity to present it to the audience. Next slide, please. So yes, as I said, we are now officially registered since April 2023. The platform is registered in Belgium, and it took many years of discussions for seed companies to come together and to establish the rules under which they would like to operate this license platform. So the idea is really to facilitate the access to patented trade. That means essentially facilitating the way that companies can get a license between each other on patented traits. So you can see on the slide that currently there are 10 companies member of the licensing platform. And these companies are of different sizes. They are multinationals holding patents such as Corteva, KVS, Bayer, Syngenta, BASF, or Limagrin. But there are also some smaller companies where patents are still not included in commercial varieties of their crops. For example, Europlants or HZPC working on potatoes, and Elsom Zackerman working on cereals where there are no patented traits yet in commercial varieties. So the companies decided to come together for different reasons. And they established this licensing platform, and I will explain you it on the next slide, please. What was the purpose of creating this license? What the seed companies had in mind when they wanted to establish some rules? So first of all, so this is a bit a list of constraints that are often heard against patents. And seed companies try to address these constraints by building a licensing platform which could be fair for everyone. So first of all, it's about access to breeding material. We know that breeding a new variety requires access to the source material, and it's very important that the access remain as free as possible. And we know that patents in commercial varieties may hinder free access to breeding materials. So the motto of the licensing platform is a bit free access, but not for free. That's what motivated and what the seed companies try to keep in mind when building the rules. Then secondly, what we can fear is that patents can also create monopolies. They can create concentration, and that's not good for the breeding sector, where sharing germplasm is critical. It's better to try to avoid monopolies. That's why one of the rules of the licensing platform is that a company has the obligation to provide all her patented traits in the platform, and she has the obligation to license it to any member asking for a license. So this is really limiting monopolies. And in the discussion we had with the policymakers, especially at the EU level when negotiating LGT regulation, this rule of all patents in the licensing platform and obligation of licensing is really something that made sense for policymakers, and that's why they were very enthusiastic to hear about the licensing platform, and they copied some principles, and we will keep working together with the EU policymakers. Third limit that we can find about patents is for small and medium companies. We acknowledge that it's probably easier for big companies, multinationals, that have a legal service in-house to negotiate this kind of license. For smaller companies that don't have a legal department, or it's complicated to know how to start to contact, to get license, and they would probably go to an external law firm to get advice on the licensing, and this is very costly. So clearly this is a constraint for small and medium companies. So this was also the aim of this licensing platform, to facilitate the licensing process, keeping in mind that small and medium companies would really benefit from it, and that also serves the fact that patented trait would be available to anyone, any company size. And last point, we talked about it, Anaïc presented that transparency is also one major concern about patent, how to make sure that the variety a farmer is using or a breeder is using contains a patented trait or not. The seed sector, the private seed sector, has worked a lot on transparency, since many, many years, they didn't wait for the ACLP. We have a database that Anaïc mentioned, the Pinto database managed by Euroseeds, which is quite exhaustive, at least for the agricultural crops, it is exhaustive. And you can find there all the varieties where there is a patented trait. And this is the database that ACLP is using to provide elements on the patented traits that are inside the licensing platform. Next slide, please. So the ACLP is European focused. We are here talking about patents from the European Patent Office territory, which goes from Iceland to Turkey, which also includes Switzerland. So this is larger than the European Union. Many countries that are not members of the EU are also part of the territory of the ACLP, so the territory of the European Patent Office. And we added Ukraine and Russia to this territory. And the board is, of course, discussing the extension of the territory. The idea would be to provide this platform to as many breeders as possible. Next slide, please. Thank you. So what kind of traits are on the platform? So as I said, it's an all-in approach. ACLP members have to provide all their patented traits. They cannot retain some patented trait for exclusive licensing. Exclusivity is not an option anymore. And they have to provide everything, and they have to also agree to license the patented trait to any member asking for it. So currently, we have 95% of all the patented traits on the market in Europe that are part of the licensing platform. You saw the names of the companies member of the ACLP, and they represent 95% of the patent holders. And they all agreed that being part of this licensing platform is important. The ACLP covers agricultural crops. So these are the classic CPVO list. This includes maize, sugar beet, rye, potatoes, all the agricultural crops, ornamental crops, and fruit crops. So these are part of the licensing platform. And the other licensing platform, the international licensing platform that Thorsten will present, is for vegetables. So it works more or less on the same principle than the ACLP, but it is existing since longer, and it is dedicated for vegetables. So that's a bit how we divided the crops between ILP and the ACLP. Next slide, please. Thank you. So on this slide, and this is my concluding slide, I will explain you how concretely it works when two seed companies are starting to discuss their licensing, a license. So if we start the process on the top left part of the slide, we have a breeder, A, who wishes to use a commercial variety from a breeder B to include it in his breeding program. The first step that this breeder will do is to check on Pinto if the variety contains patented trait and if it is available through the ACLP. So next slide, please. This is the Pinto database of Euroseeds, available to anyone who would like to check any kind of information. But for breeders, it is quite interesting. You can see here that it is a sugar beet variety, and we have the name of the variety, Baronica KVS. And we can see that there are 3 patents on this 3 patented traits in this variety, that they are owned by KVS, and that KVS is a member of the ACLP. That's why we have the icon ACLP behind each patent. If, of course, you can get all the details about the patents when you click on the patent number, then it sends you to the European Patent Office website where you have all the description of the patents. Yeah, so that's the first thing that a breeder would do. Can we go to the previous slide, please? Thank you. Then we go to the third step. If both breeders are members of the ACLP, the breeder A will simply inform the breeder B that the variety will be used in his breeding program by a simple notification via a document that we have prepared on our website. It is a non-assert template. And this is one of the first major principles of the platform. It is to put in place a limited breeders exemption in the 41 countries of the territory of the ACLP. As Anaïc explained, there are different rules on patents and there are different legislations around what is authorized to do or not in terms of research and breeding. And there are only 18 countries that allows to do a research that allows a breeding exemption for patents. So it is not something which is really common. But within the ACLP, the members have decided to put in place this limited breeders exemption in the 41 countries of its territory. So that's already one big advantage of being part of the platform. You can do breeding without paying anything to the patent holder. Then the fourth step, if the patented trait remains in the new variety to be commercialized, of course, then the breeders need to negotiate a commercial license to get an authorization from the breeder B for the breeder A to commercialize a new variety with the patented trait. And these negotiations, so this is the next step, these negotiations that can be a bit complicated, especially for small and medium companies that are not used to negotiate a license. These negotiations within the ACLP are facilitated because we have a standard license agreement, which is a contract of license where all the conditions are already written and members agreed to this license agreement. Of course, they can differ from it if they both agree that they would like to differ from it, but the idea is to use it because it's simple, everything is already written, and it is a mandatory licensing. So there is no way that a patent holder would refuse to provide a patent. So it's compulsory for both parties who would like to enter in a contract. It's compulsory to finish and to come to final terms for their licensing agreement. So the only element that needs to be negotiated so the negotiations are always taking place confidentially and bilaterally. So I am the managing director of the ACLP, but I don't know of any negotiations that are taking place between companies. Everything is confidential and bilateral. Companies know, of course, who is a member of the platform. They have the contact details, so they know they can get into contact between each other. But I am not informed of any license, the number of license, the number of the royalty fee. I don't know of anything. The only case I would know about a negotiation that is taking place is in case companies cannot come to an agreement on the royalty fee, because the royalty fee is the only element that needs to be negotiated. So in the standard license agreement, the contract to get a license, everything is written, all the conditions are already written, all the legal conditions. Only the royalty fee needs to be negotiated between the parties. And in case parties cannot agree on the royalty fee, we have put in place an arbitration system that will guarantee that anyway, if parties cannot come to an agreement between themselves, then arbitrators will conclude the contract and will decide on the royalty fee. Can we go 2 slides later, please? Thank you. So this is the baseball arbitration, and it starts in case negotiations don't conclude within 6 months between parties. And it is called baseball arbitration because arbitrators, so we have a list of 10 arbitrators, which are seed experts from the public or the private sector who have worked in multinationals or small companies, different crops of expertise, different backgrounds. So we have legal, we have business, we have a CEO, we have license experts, etc. So we have really a good range of experts. 3 arbitrators will be chosen to judge a case, and these arbitrators will have to decide if the market value of the patented trait is closer to, here in my example, 5 or 7% that are the royalty proposition of the parties. Arbitrators cannot decide that 6% would be fine. No, it's called baseball arbitration, so it's a specific kind of arbitration, and it's quite harsh, it's quite brutal for parties. And the idea is really that parties should not come to use arbitration. So in 3 years of functioning, we have never had an arbitration. Parties always have come to an agreement because they may lose a lot in case arbitrators choose the other proposition over their proposition. So it's really not a guarantee, but a strong advice for party to make reasonable proposition close to the market value, so the licensing contract can be concluded. So that's how the seed sector organized the licensing platform of the ACLP. And as I said, it created quite some enthusiasm from the policymakers in the EU at least. And of course, I remain at the disposal of anybody who would like to get more information on the functioning of the platform. Thank you.
Many thanks, Helen. Und jetzt geht's wieder weiter auf Deutsch und ich freue mich auf die Präsentation von Thorsten Berg von BASF.
Vielen Dank zunächst für die Einladung, hier zu sein. Vielen Dank auch an meine beiden Vorredner, Anaïc und Helene, für die schönen Ausführungen. Die meisten der Zuhörer sind wohl deutschsprachig, daher wurde ich gebeten, diese Präsentation auf Deutsch zu halten. Die Slides sind auf Englisch, ich hoffe, das ist kein Problem. Ansonsten gerne nachher auch im Nachgang Fragen stellen. Hier gleich zu Beginn auf der nächsten Folie würde ich zunächst mal eingehen auf einen Überblick, was ist denn ILP eigentlich, International Licensing Plattform. In großen Teilen ist es ziemlich ähnlich wie die Plattform ACLP, die wir gerade gehört haben. Es gibt ein paar Unterschiede. Der erste große Unterschied ist, das haben wir auch schon gehört, dass diese Lizenzplattform sich ausschließlich und exklusiv hier auf Vegetables, auf Gemüse Crops fokussiert. Und ein zweiter wesentlicher Unterschied zur ACLP ist auch, dass die Breite hier oder die Anwendbarkeit international ist. Das heißt, diese Plattform ist nicht auf Europa limitiert, sondern eben international. Ausgeschlossen von vornherein aus dieser Plattform sind Patente betreffend GM-Trades. Ähnlich wie der ACLP ist, dass die Zielsetzung von ILP war von vornherein die, dass wir gesagt haben, der Zugang zu patentiertem Material für das Züchten soll frei sein. Und zugleich gibt diese Plattform auch die Möglichkeit, dass man hier jederzeit auch bei Kommerzialisierung von neuen Sorten die Sicherheit hat, hier FTO, also Freedom to Operate, zu haben. Also ist es von vornherein allen Mitgliedern zugesichert, dass sie in jedem Fall Lizenzen bekommen, und zwar unter vorverhandelten Standardlizenzverträgen, wo nur noch in Anführungszeichen, ähnlich wie bei ACLP, dann die eigentliche Gebührensatz verhandelt werden muss. Das Ganze, auch die Teilnahme, hier Mitglied zu werden, soll unter fairen und vernünftigen Kosten möglich sein. Deswegen gibt es auch hier einen graduellen Gebührensatz für die Teilnahme, der davon abhängig ist, wie groß das Unternehmen ist, das hier eben teilnehmen möchte. Auf der nächsten Seite ein kurzer Überblick über die Organisation von ACLP. Auf der rechten Seite hier ein Überblick erstmal über alle Mitglieder, die heute schon dabei sind. Mittlerweile zählt ACLP 18 Mitglieder, 11 waren damals bei der Gründung dabei. Damals heißt schon ein bisschen länger her, 12 Jahre fast, im November 2014. Die Mitglieder sind unterschiedlicher Größe. Es gibt größere Unternehmen wie das ich auch vertrete, hier BASF, aber auch andere Teilnehmer von SMEs oder KMUs, kleine, mittlere Unternehmen sind hier ebenfalls vertreten. Die Anzahl der Patente ist einsehbar auch über ein Register, das von ACLP angeboten wird, wo alle Patente der Mitglieder eingespeist werden. Momentan zählen wir ein bisschen mehr als 350 aktive Patentfamilien. In der Vergangenheit war es noch mehr, manche sind schon abgelaufen, deswegen sind es im Augenblick etwa 350 aktive Patentfamilien, die etwa 82% aller Gemüsetrades und Trade-Patente abdecken. International, eben wie gesagt, nicht nur auf europäischer Ebene. Was auch allen Mitgliedern gemein war schon bei der Gründung und auch allen neuen zugetretenen Mitgliedern gemein ist, das gemeinsame Verständnis, dass wir eben auf der einen Seite Patente dringend brauchen, um hier Innovation voranzutreiben. Wir haben schon von Anaïc Cordoba zu Beginn auch gehört, wir reden hier nicht über kurzzeitige Erfindungen, sondern das sind ja Innovationen, die in der Regel Jahre vorab brauchten, um zustande zu kommen. Und um diese Innovation eben schützen zu können, ist ein gemeinsames Verständnis da, dass wir diese Patente brauchen. Denn die Alternative zum Patent, man kann es nicht oft genug sagen, das ist ja nicht keine Patente einfach, sondern das heißt dann alternativ Geheimhaltung oder eben keine Innovation. Auf der anderen Seite aber auch haben wir ein gemeinsames Verständnis dafür, dass es hier eine Transparenz geben muss und eine Zugangsmöglichkeiten geben muss, um andere Züchter hier nicht auszuschließen durch Patente, sondern eben diesen Zugang zu ermöglichen. Nach einem ähnlichen Grundsatz, wie wir es eben schon von Hélène für ACLP gehört haben, der Zugang für alle, aber eben kein freier Zugang, also Access for all, but not free access. Die Lizenzen wurden bisher auch schon abgeschlossen, nicht nach den Standardvereinbarungen, die von ACLP angeboten werden, aber durch die Möglichkeit eben, dass hier auch bilaterale Abkommen geschlossen werden können, gab es hier schon einige Lizenzschlüsse zwischen den Mitgliedern, die aber ähnlich wie auch in ACLP natürlich geheim gehalten werden, der Öffentlichkeit nicht zugänglich gemacht werden. Auf der nächsten Seite nochmal ein Überblick in aller Kürze auch, weil das meiste ist ziemlich ähnlich wie in ACLP, die Grundlagen von dieser Plattform für Vegetables. Zum einen ist eben hier eine ganz klare Zielsetzung, dass man hier Transparenz erzeugen möchte. Was ist denn eigentlich geschützt? Daher sind alle Mitglieder verpflichtet dazu, alle neuen relevanten Patente auf Vegetable Trades zu veröffentlichen in einem ACLP-eigenen Register. Das ist für alle einsehbar, dass man also unmittelbar die Möglichkeit hat zu sehen, welche Trades hier patentrechtlich geschützt sind. Der zweite Punkt ist auch Free Breeding. Wir haben schon gehört, in vielen Ländern gibt es ja dieses Züchterprivileg, dass das Züchten an sich auch unter Patenten jetzt schon möglich ist, gesetzlich möglich ist. Weil es aber eben nicht in allen Ländern möglich ist, wollten wir hier allen Mitgliedern die Sicherheit geben, dass in dem Augenblick, wo man Mitglied wird von dieser Plattform, dieses Züchterprivileg auch in allen Ländern gültig ist, dann eben unter den vertraglichen Verpflichtungen unter ACLP. Die einzigen Voraussetzungen hierfür sind, dass derjenige, der dann eine patentgeschützte Sorte nehmen möchte fürs Züchten, dass dem entsprechende Patentinhaber vorher meldet und das Material, das zur Züchtung eingesetzt ist, auch hier legal erworben wurde. Die zweite Garantie, die den Mitgliedern hier unter ACLP gegeben wird, ist die der Lizenzen. Das heißt, auch in dem Augenblick, also nach dem Züchten, wenn ich dann zu einer neuen Sorte gelangt bin, die immer noch patentrechtlich geschütztes Material enthält, dann habe ich die Garantie, eine Lizenz zu bekommen unter den Maßgaben des ACLP. Das heißt, ich habe von vornherein die Sicherheit, dass ich hier FTO, Freedom to Operate, haben werde. Und dann kann ich entweder zurückgreifen auf die vorgefertigten Rahmenverträge, diese SLA, Standard License Agreements, oder ich kann bilateral mit dem jeweiligen Patentinhaber dann ins Gespräch gehen und dann ein zweiseitiges Abkommen schließen. Wenn keine Einigung in einem bestimmten Zeitraum, ich meine, es sind 3 Monate, zustande kommt, dann gibt es den ähnlichen Mechanismus, wie er eben auch schon für ACLP vorgestellt wurde, die Baseball Arbitration. Das heißt, es werden von beiden Seiten 2 Arbitrators vorgeschlagen, die wiederum einen Dritten bestimmen, die dann sich die beiden Vorschläge anhören und dann zu einem Schluss kommt, welcher der beiden Vorschläge am Ende angenommen wird. Ein kleiner Unterschied hier noch, wenn es dann zu so einer Baseball Arbitration kommt und dann zum Ergebnis kommt, dann wird das Ergebnis auch veröffentlicht, sodass dann auch andere Mitglieder die Möglichkeit haben, unter denselben Bedingungen, die hier abgeschlossen wurden, dann auch einen neuen Vertrag abzuschließen. Auf der nächsten Seite dann noch ein Überblick nochmal über den Scope von ACLP und was es auch nicht umfasst. Also nochmal, der geografische Rahmen von ACLP ist international. Dazu muss man aber auch sagen, international für den Scope von ACLP, das sind eben die Patente für Gemüsetrades. Nicht umfasst sind die Sortenschutzrechte, die Plant Variety Protections, PVPs, die wir zu Beginn schon von Anaïc Cordoba gehört haben. Der Grund dafür ist, dass die nicht umfasst sind, denn dafür gibt es schon weitestgehend international eine Regelung, die UPOV-Regelung nach 1978 oder 91, wo die meisten Mitglieder, auch die größten Märkte schon mittlerweile umfasst sind. Das ist auf der Karte hier angezeigt. Also UPOV regelt schon sehr viel für diese Sortenschutzrechte. Deswegen ist das bewusst ausgenommen aus dem ACLP. Nicht umfasst sind auch Patente auf die Verfahren an sich, also die nicht konventionellen Züchtungsverfahren. Und wie schon eingangs erwähnt, nicht umfasst sind auch die GM-Trades. Und damit habe ich mich versucht kurz zu fassen, weil ja vieles schon für ACLP gesagt worden ist, das dann ähnlich auch für ACLP zutrifft. Und jetzt freue ich mich natürlich auf die Fragen und Diskussionen.
Vielen, vielen herzlichen Dank an dieser Stelle für alle Präsentatoren und Referenten. Wir eröffnen jetzt die Fragerunde. Dazu begrüße ich auch Regina Ammann. Sie ist Leiterin Nachhaltigkeit und Public Affairs Schweiz bei Syngenta. Ich habe es bereits gesagt, Sie können Ihre Fragen einfach in den Chat schreiben. Sie können dies auf Französisch, Deutsch oder Englisch tun. Ich werde die dann gerne an die Referenten weiterleiten. Und wir haben bereits eine erste Frage. Mainly dedicated to Hélène and Anaïc. I quickly read it out to you. How do you reconcile patenting and plant variety protection with the respective regulations by international law, like CBD? This is the Convention on Biological Diversity, the ITPG-RFA, the International Treaty on Plant Genetic Resources for Food and Agriculture, and UNDROP, which is the United Nations on the Rights of Peasants and Other People Working in Rural Areas. Who wants to start? Anaïc, you want to start?
I don't know if I want to start, but I will start. I'm not sure I'm getting the questions. How do I reconcile the different international convention that was mentioned?
Exactly.
So for me, it's a bit too bright questions. I think these international conventions are already functioning together, and I don't see right now point where this international convention would not work together. So can't really answer the questions. Maybe Ellen, I don't know.
Yes, so in these international conventions, there is always a part on IP. I remember on the IT PGIFA that it's written that IP should not be requested on the germplasm that is used, so the public germplasm that is used. So there is always a provision about IP, but I think they are more or less all functioning together, and the IP conventions per se, so UPOV convention. So at the international level, there is no patent convention. There are always regional conventions regarding patents, but they are clear and there are apparently no overlaps. And when there were uncertainties, the competent authorities always came to provide the requested clarifications. I'm especially thinking in the EU, where, or even, at the European level, at least, when there were uncertainties about the essentially biological processes and products obtained via these processes, there was always a jurisdiction able to clarify the rules. And this did not impact, I think, the other international conventions that were mentioned.
Many, many thanks. I would like to continue with you, Anaïc. But when we talk about new genomic techniques, we often hear people that they are worried that there's going to be a massive flood of patents. How would you respond to those fears, and maybe then as well the opinions of the other presenters here in the call?
Yeah. So as I mentioned, we at the IPI make some analyses and commission several studies, also patent landscapes about CRISPR technologies and patent on CRISPR technologies, and maybe can give you some results. Looking for the results. So we can see that at the global situation, there are no more than 5,000 CRISPR-related plant patent families worldwide. So not all these patents are registered in Switzerland or in Europe. Most of it are in the United States of America and China. And maybe I can give you some data from the IPO. So that show that companies are responsible for about 2/3 of patent filings in this field. And universities and research centers are responsible for about 20% of filings in this field. And for the companies filing, 50% of the filings are coming from small and medium-sized enterprise. So we see that the patent system in this field is not used only by large corporations, but also by smaller innovative companies. And as I mentioned during my presentation, I think the patent law is not the first factor that will impact the increase in patent trade in plant breeding. That will come. So probably the most important factor is the regulation for these new genome techniques, I think. Or maybe I can give you one more information. That's also data from the IPO. And we can see that the grant rate in this field is also lower than average, around just 1/3 for the breeding techniques and patent on traits, compared to 60% for other fields of patenting. So that's all.
Thank you. Anyone who would like to add on those, how you would respond to those fears?
I can bring an element that the company's member of the ACLP often raise is that when doing an assessment of a patent, the patent examination office look at what we call the state of art, because the invention has to be new and innovative. So they are looking of the state of art, what is already published. And the number of publication is increasing more and more. The number of research by public institutes, also private companies, is really increasing. So the state of art is becoming more and more complete, and it's going to be harder to find something innovative and new in the genome of plants. So that's what they see, that the number of publication is really increasing. So it's going to be harder to find something really new. So they don't really see that the number of patents will absolutely explode because the criteria of patentability are very important and they have still to be met. Innovation and novelty are amongst the hardest one to meet.
Vielen Dank, Thorsten. Ich sehe, du nickst. Vielleicht noch schnell aus deiner Sicht die Perspektive vom Unternehmen.
Ja, also das Gleiche nochmal, was Helene sagte, das fiel mir auch ein. Wir haben ja immer noch die Patenthürden auch, Neuheit, erfinderische Tätigkeit und im Zuge dessen, dass Sequenzen ja immer mehr bekannt sind und auch die Funktionen von Sequenzen bekannt sind, wird es natürlich immer schwieriger, ganz gezielt Mutationen zu finden, die dann ganz überraschend zu irgendeinen besonderen Effekten führen. Und hier jetzt eine Explosion zu erwarten an Patenten einfach ist sehr unwahrscheinlich, weil man eben dieses wirklich tiefe Verständnis haben muss, um gezielte Mutationen über NGT, über CRISPR einzuführen, das ja nicht mit einem plötzlichen großen Anstieg von Patenten zu rechnen ist. Und das andere nochmal betonend, es geht ja nicht darum, bestehende Pflanzen und Sorten zu schützen. Das hatten wir schon zu Beginn. Anaïc Cordoba hat das ja schon schön geschildert, sondern es geht darum, die technische Innovation schützen zu können. Und diejenigen Züchter, die das gar nicht nutzen wollen, sondern weiter auf konventionelle, essentiell biologische Verfahren zurückgreifen wollen, die sind davon nicht betroffen. Also es geht ja nur um diejenigen, die selber auch solche technischen Verfahren wie CRISPR-Cas nutzen, die dann sich überhaupt darüber Gedanken machen müssen über den patentrechtlichen Schutz.
Und wenn ich hier vielleicht gleich ergänzen darf, auch große Unternehmen wie jetzt meines in Gent, die sind ja auch angewiesen auf Transparenz, um ihre Forschung voranzutreiben. Und es war nicht einfach ein Geber-Mindset, der zur Gründung der ACLP geführt hat, sondern eben auch, dass wir eben auch wissen müssen, was andere für Trades haben, damit wir auch dort keine Patente von unseren Mitbewerbern verletzen. Das ist das eine. Und das andere noch, zu den Zahlen, die Anaïc vorhin gebracht hat. Gerade kleine Unternehmen sind Startups, die sind sehr darauf angewiesen, dass sie Patente haben können, wenn es denn patentierbar ist. Weil Investoren schauen auch darauf, ob ein Return on Investment möglich ist, bevor sie investieren. Und da müssen Innovationen, und das geht über die Pflanzenzucht hinaus, geschützt werden können, damit auch ein Investor so die Sicherheit hat, wenn ich in dieses Startup investiere, dann ist auch diese Innovation für einen gewissen Zeitraum geschützt. Und das erklärt auch die hohe Anzahl von Patenten aus öffentlichen Institutionen, aus denen ja dann auch sehr häufig Startups hervorgehen.
Vielen Dank. I quickly want to jump back to you, Helen, because just for clarification, you said free access, but not for free. Could you again explain how we should understand this?
So basically, free access in the sense that there should not be any constraint for accessing patented trade. There is no obstacles to access the patented trade that are in the platform. One thing I did not mention is that any company that conducts a breeding activity in the territory is welcome to join the licensing platform. They don't have to own patent. They don't even have to use patent. They can just come. There is only a small membership fee that has to be paid annually. And this membership fee is really limited. It depends on the size of the company, and it aims really at covering the administrative cost of running the association. So it's really limited. It's even €0 for small companies until 2031. So there shouldn't be any obstacle to come to the platform. So this is what we call the free access. There is no obstacle, and nobody can refuse to give you a license once you are a member of the platform. But this is not for free because, of course, innovation has to be rewarded. The work of breeders that have created the patented trade has to be rewarded. Getting a return on the investment is very important in the breeding sector to keep innovation going. So, of course, there is a royalty fee behind each negotiation of license.
Many thanks. Jetzt würde ich noch ganz gerne eine Frage an Thorsten stellen. Die ACLP beinhaltet aktuell keine gentechnisch veränderten Eigenschaften. Wieso ist das so? Und ist es geplant, dass sich das dann auch öffnet, wenn neue Genomic Techniques zugelassen würden?
Ja, also GM genau ist im Augenblick ausgeschlossen, ähnlich auch wie bei ACLP. Der Grund dafür ist, dass die Mitglieder hier unterschiedliche Herangehensweisen, inwieweit sie überhaupt GM-Trades in ihren Produkten anbieten. Und also manche bieten es gar nicht an und manche eben schon. Und dann war der Wert, hier GM-Patente mit reinzubringen, einfach sehr unterschiedlich gewertet. Dann kann man sich vorstellen, wenn die einen da die Forschung betreiben und die anderen überhaupt nicht. Und dann ist dieser Benefit nur für die eine Seite relevant, dass man dann gesagt hat, dann lassen wir es ganz raus, damit es hier kein Ungleichgewicht außer zu Kosten-Nutzen.
Vielen Dank. Ich habe eine weitere Frage im Chat. Ich bin noch nicht ganz sicher, ob ich es richtig verstehe. Ich versuche es mal. As I'm thinking this system coexists since long in vegetables. Could one comment on the pros and cons from past years into this sector and so comment on potential issues if this will be more intensively used in raw crops? So ging es mir auch. Ich habe es nicht ganz verstanden. Vielleicht warten wir noch sonst auf weitere Fragen. Ich verspreche Ihnen, dass wir gerne auf Sie zukommen und die Frage nochmal bilateral klären. Weitere Fragen oder vielleicht noch Kommentare von unseren Präsentatoren hier in der Runde, um vielleicht nochmal etwas anzusprechen.
Ja, also vielleicht fange ich kurz an. Also was mich natürlich immer sehr interessiert in diesen ganzen Diskussionen, die wir jetzt schon hatten, auf europäischer Seite oder die wir jetzt heute auch hier in diesem Forum haben, ist nochmal konkreter zu verstehen, wo denn konkret Sorgen und Nöte liegen, die hier vorgebracht werden. Also immer wieder, wenn ich in Diskussionen dann bin, dann frage ich auch nach konkreten Beispielen, wo denn Patentschutz denn bisher im Wege war für die Arbeit von Züchtern unterschiedlicher Größe. Bisher fehlt mir da ein konkretes Bild, was da wäre ich dankbar dafür, so eins zu bekommen, dass man dann darüber auch hier offen sprechen kann.
Noch von jemand anderen vielleicht ein Schlusswort. Es hat keine weiteren Fragen mehr im Chat. Wenn es keine weiteren Fragen gibt, dann würde ich jetzt diesen Swiss Food Talk schließen. Ich bedanke mich natürlich nochmals bei allen Präsentern hier in der Runde. Ich bedanke mich bei Ihnen fürs Dabeisein. Ich hoffe, Sie beim nächsten Talk wieder begrüßen zu dürfen. Ich wünsche Ihnen jetzt einen guten und einen wunderbaren Tag.